Welcome to the Good Landlord training. My name is Tom Wood, and I'll be your presenter for these modules. This training has been designed to meet city requirements for the Good Landlord program, which is necessary to get a discount on your annual business license fee. The training is divided into two parts. Part 1 is designed as a 2-hour refresher course for landlords who have previously taken part in a 4-hour first-time training. Part 2 is a continuation for new landlords who are taking part in this program for the first time. Part 1 focuses on practices that will help create and maintain successful landlord-tenant relationships. It covers the Utah Fit Premises Act, evictions, property abandonment, and fair housing. Part 2 focuses on best practices, including screening, code compliance, inspections, and crime prevention through environmental design. Following each section, there will be a short quiz. Upon completion of the test, a Good Landlord certificate will be emailed to you. In turn, you will need to provide a copy of the certificate to the city to receive your business license discount. Many landlords have asked, how did the Good Landlord program start, and why do I have to take this training? We hope to be able to answer many of those questions for you today. For many years, Ogden City had problems with crime in rental properties. They also had many complaints about the poor condition of apartments located throughout the city. They decided to charge landlords more for their business licenses because it was felt that they used more city services than owner-occupied dwellings. State law allows local governments to impose disproportionate business license fees to rental units due to increased costs to municipalities. Those costs include calls for police, fire, and emergency services. A disproportionate rental fee means a license fee on rental housing based on the disproportionate costs of municipal services caused by rental housing. Currently, Utah requires cities that impose a disproportionate rental fee to establish a Good Landlord program, allowing the landlord to qualify for a reduction in fees. The law allows local governments to create a program that's realistic for their city. The criteria for the Good Landlord program is as follows. 1. A landlord completes a landlord training program approved by the city. 2. Landlord implements measures to reduce crime in rental housing. And 3. Landlord operates rental housing in accordance with applicable city ordinances. Since starting in 2004, Ogden has experienced a 30% reduction of crime on rental properties by the year 2008, less than 4 years after starting the program. And as of 2014, more than 85% of Ogden landlords were participating in the program. Those who choose not to be part of the program pay the higher fees. The Good Landlord program helps reduce crime. It lowers the cost for services to cities and creates higher income from those landlords who choose not to participate. These are the primary reasons that 15 Utah cities now have a Good Landlord program, and more cities are starting them every year. As part of the Good Landlord program, participating landlords are encouraged or required, depending on the city, to first, run a credit and criminal background check on every applicant. Second, to evict tenants who create problems. Third, to maintain their properties to code. And fourth, take a city-approved Good Landlord training class. In return, cities agree to first, reduce the per-unit license fee. Second, provide information on criminal activity. And third, provide training and education on city regulations and crime prevention. Before starting the modules, we'd like to take a few minutes and do a quick pre-test. These will be questions that will be covered throughout our training and this gives an opportunity for you to assess your current knowledge. Question 1. True or false? A 3-day pay or vacate notice requires a tenant to move out. That is false. A 3-day pay or vacate is the first step for a landlord if rent is not paid. While moving out is an option, normally the best result is to have the tenant pay the rent owed. Question 2. True or false? If I only have one rental unit, it's okay to discriminate against someone in a protected class. That is false. While a landlord may be exempt from fair housing laws because they have less than 4 units, it's never a good practice to discriminate against someone because they're in a protected class. Your exemption doesn't mean you won't be sued. Question 3. True or false? The Utah Fit Premises Act requires landlords to fix air conditioning if it breaks. That is true. If an air conditioner is provided at the time a tenant first occupies the rental, then the landlord must make repairs to the air conditioning within 3 days of being notified by the tenant. Question 4. True or false? The best way to screen tenants is to take several applications, compare them to each other, and choose the best one. That is false. The best way to screen tenants is to set written minimum qualification standards and accept the first applicant who meets those qualifications. Question 5. True or false? Routine quarterly inspections are a good way to maintain property value. That is true. Regular inspections help identify problems before they become serious and allow landlords to address tenant problems such as cleanliness, extra occupants, drug use or criminal activity, or unauthorized pets. Question 6. True or false? Abandoned personal belongings of former tenants must be kept in a secure location for 15 days. That is true. Utah law changed in 2013, lowering the number of days landlords must hold belongings from 30 days to just 15. Question 7. True or false? Religion is a federally protected class. That is true. Federal law prohibits discrimination against any individual on the basis of their religion. Question 8. True or false? There is nothing you can do to help reduce crime if your rental is in a high crime neighborhood. That is false. Simple things such as proper screening, good environmental design, and routine inspections will help reduce and sometimes eliminate crime. Question 9. True or false? Putting things in writing will help reduce problems with tenants. That is true. Having things in writing, such as screening criteria, applications, lease agreements, and lease addendum will help tenants have fewer misunderstandings and will protect landlords from fair housing complaints. Question 10. True or false? My no pet policy means I don't have to accept someone with an untrained service animal. That is false. A request for a service animal is a reasonable accommodation to a no pet policy, and there is no requirement that the animal has any kind of training as a service animal. So how did you do? Most landlords know the answers to these questions, but some of them might be new for you. We cover each of these issues and more in our training modules. If you have specific questions, you can review individual modules after completing the course. Now we'd like to discuss some basics of property management, what we call our ABCs of property management. The first is to always get everything in writing. You and your tenant will likely remember things differently, so write it down. This includes having a written lease, application, and delivering all notices in writing. Next is that bad tenants scare away good tenants. If you have a fourplex and rent to one bad tenant, your 3 good tenants will move out long before your bad one ever does. Check credit and references. Don't act desperate. Having no tenant is better than having a bad tenant. Don't allow individuals you did not approve to live at your property. If someone unauthorized moves in, get them to fill out an application, put their name on the lease, or if they don't qualify, have them move out. Next, evictions take time. Don't wait to start one, and don't believe every story that you hear. A lot of people fall on hard times. It doesn't mean that they can't still find a way to pay their rent. Follow your written guidelines, not your gut feeling. Good landlords attract good tenants. Protect your reputation and your property. Hidden fees and costs make your tenants angry. Be honest and upfront about what you charge. It's okay to charge a fee, just put it in writing so that your tenants are aware of it. Inspections should be done quarterly. These can be detailed, or these can be brief, but you need to be in your rental property 4 times a year to make sure that your tenant is taking care of things properly. Jumping through hoops is no fun for anyone. Make your residency requirements simple to understand. Kids are part of a protected class. Don't discriminate against families with kids. Large deposits lower your risk. Whether charging a security, pet, or other deposit, the larger the deposit, the lower your risk. Charge what the market will allow. Making money is not a crime. Charge as much rent as the market will allow. Nobody's perfect. Don't expect perfection from your tenants, and perhaps they won't expect it from you. Hold them to the terms of your lease, and provide for them the obligations that you've committed to in the lease. Observant neighbors can help keep an eye on your property when you can't be there. Get to know them, give them your contact information. Professional landlords run their rentals as profitable businesses. Quickly respond to maintenance requests. The longer you wait, the more problems might arise. Respect your tenant's property. Remember that your rental is your tenant's home. State-specific forms are important, especially should you wind up in court. Turnover is often preventable. Convince your tenants that you can treat them better than anyone else, and they'll stay with you for many years. Utility shutoff directions should be provided to tenants in case of emergencies. Vacations by tenants are great, but they should contact the landlord if they're going to be gone for extended periods. Water damage can be costly. Perform inspections with purpose. Expect that your tenants will follow your rules. Address rule breaking immediately. Yearly rent increases are anticipated and usually budgeted by tenants. Don't be afraid to raise the rent. And finally, zoos are for housing animals. Have rules and limit the number of pets. Also, charge pet fees and deposits. In this module, we'll be discussing the Utah Fit Premises Act. Most landlords recognize that their rental units are businesses and want to protect their investments by taking good care of their properties and tenants. The Utah Fit Premises Act outlines the duties and responsibilities of landlords and of their tenants. Prior to beginning, we'd like to take a short pre-test to test your knowledge of the Utah Fit Premises Act. Question 1. True or false? Landlords must make all repairs within 2 days of problems being reported by tenants. That is false. In some instances, landlords can take up to 10 days to make repairs. Question 2. True or false? If a landlord does not make requested repairs, a tenant may make the repairs themselves and deduct the cost from their rent. That is true. Repair and deduct is an option that is available to tenants under the Fit Premises Act. Question 3. True or false? The Fit Premises Act only applies to cities with good landlord programs. That is false. The Fit Premises Act applies to all rental properties throughout the state of Utah. Question 4. True or false? As long as my tenants don't complain, I don't need to worry about following the Fit Premises Act. That is false. Landlords have an obligation to provide a fit premise for renters. Question 5. True or false? A tenant can withhold their rent until I make repairs to their apartment. That is false. Tenants must be current on all their payments to exercise their rights under the Fit Premises Act. So what is the Utah Fit Premises Act? The Utah Fit Premises Act outlines landlords' and tenants' rights, responsibilities, and duties, as well as renter remedies. There are 3 responsibilities of landlords under the Utah Fit Premises Act. The first involves dangerous conditions. The second, habitability issues. And third, issues of deficient condition. For dangerous conditions, it's something that poses substantial risk of imminent loss of life or significant physical harm. A tenant can notify the landlord by any means, including phone or text. Corrective action must commence within 24 hours of notification. As an example, if a tenant calls and reports that a light switch sparks and smokes when turned on or off, a landlord must start making repairs within 24 hours of the notification. Owners also have duties of habitability. Landlords must provide a safe and sanitary rental and provide the following: running water, working plumbing and sewer, operational electrical systems, heat and hot water, locking doors and windows, and you must maintain any air conditioning in working order. If there is no air conditioning unit, you will have no obligation to install one. You merely have to maintain any existing air conditioner. Under duties of habitability, landlords must make substantial completion of repairs within 3 days. If you cannot or do not wish to make the repairs, you can choose to cancel the lease and refund the security deposit and a prorated portion of any prepaid rent. An example of an owner's duty of habitability. A tenant calls on Tuesday morning to tell you their furnace has stopped working and they have no heat. You must repair or replace the furnace by Friday morning to be in compliance with the Fit Premises Act. Despite having 3 days to make the repairs, however, a good landlord makes the repairs as quickly as possible. Under that same example, What if a landlord can't make the repairs? That same tenant calls on Tuesday morning to tell you their furnace has stopped working and they have no heat. You must repair or replace the furnace by Friday morning to be in compliance with the Fit Premises Act. However, a new furnace isn't available from the supplier for 7 days. A landlord could cancel the lease, or they could provide space heaters for a week, meeting the requirement to provide heat. Here's another example of the duties of owners regarding habitability. You receive a call from a tenant telling you that there is water gushing from the middle of the driveway in front of your rental house. After getting the water turned off, you contact a plumber who tells you that your water main is broken and the cost to repair it will be $12,000. If you don't have the money to make the repair right now, you can cancel the lease and allow the renter to move out. Owners also have duties that fall under the category of deficient condition. Landlords must maintain appliances or anything else promised in the lease. You have 10 days to make repairs under deficient condition. For example, if a tenant calls to tell you that the refrigerator has stopped working, you have 10 days to make the repairs. While you legally have 10 days, a good landlord will make repairs as quickly as possible. Owners also have other duties under the Fit Premises Act. If you have more than 2 units, then you must provide garbage receptacles. And you must provide a 24-hour notice to enter, except as provided in the rental agreement. The question often comes up, should I provide a 24-hour notice to enter the apartment? Are there any advantages to having a no-notice clause? When it comes to notice to enter, giving a notice to enter allows the tenant time to pick things up and clean the apartment prior to an inspection. However, having a no-notice clause allows you to do surprise inspections, where you may discover unauthorized pets, unapproved occupants, or drugs and drug paraphernalia. The decision on which to use is up to you. Renters also have duties and responsibilities under the Utah Fit Premises Act. The first and most important is that renters must be current on all their payments required by the lease in order to exercise their rights under the Fit Premises Act. They also need to cooperate in maintaining the rental unit, including allowing the landlord to enter and conduct maintenance. They must maintain the premises in a clean and habitable condition, dispose of garbage properly, use the plumbing, electrical, and sanitary fixtures as they were designed, and they must comply with rules of the rental agreement. If they still have problems and landlord is not doing their duty under the Fit Premises Act, renters must follow this process. Renters need to notify the landlord by serving a notice on the landlord in accordance with Utah law. Next, they have to specify on the notice the chosen remedy from the following 3 options. First, they can cancel the lease. Second, they can repair and deduct as much as 2 months' rent. Or 3, they can petition a court to require the landlord to make repairs. On the notice, they must list the required number of days the landlord has to comply with the notice. And if the landlord does not correct the problem, they exercise the chosen remedy. So what happens if the renters have broken something? Well, under the Utah Fit Premises Act, a renter may not intentionally destroy, damage, or remove any part of the rental unit. They may not interfere with the peaceful enjoyment of another renter, or deny access or refuse entry to the landlord for the purpose of making repairs. If they do, they've lost their right to exercise fit premises rights regarding the damage they've caused. The Utah Fit Premises Act does have crime victim provisions. A landlord must release a tenant from their lease if they provide the following: a copy of a police report that they were a victim of domestic violence and did not participate in the criminal act, and payment of 45 days rent as a fee for breaking the lease. Here are some key terms under the Utah Fit Premises Act that every landlord should be aware of. The first is the corrective period. For a dangerous condition, landlords have 24 hours to substantially complete repairs. For habitability issues, that period is 3 days. And for deficient condition issues, 10 days. Additional terms: substantial corrective action. An owner has taken steps to correct a deficient condition, but completion is not possible due to circumstances beyond their control. Standard of habitability. Maintaining a rental with running water, working plumbing, functioning electrical systems, heat and hot water, doors and windows that can be secured, and maintained air conditioning. Other key terms to remember: repair and deduct. A tenant may elect to correct a deficient condition and deduct the cost, up to 2 months' rent, if the owner will not take corrective action within the prescribed time. Rent abatement. After serving a notice of corrective action and having a landlord fail to correct within the specified time, a lease can be canceled and the owner has to refund the full deposit and a prorated refund of rent. All right, we've been through the Fit Premises module. Time to see what we've learned. Question 1. True or false? A landlord must repair a broken refrigerator within 3 days. That is false. A landlord has up to 10 days to repair a deficient condition, such as a malfunctioning refrigerator. Question 2. True or false? A tenant may withhold their rent in order to force a landlord to make repairs. That is false. A condition of the Fit Premises Act is that the tenant must be current on all payments in order to exercise their rights. Question number 3. True or false? A landlord does not have to make repairs if the tenant won't allow the landlord into the rental. That is true. A tenant must allow a landlord access to the rental to make repairs to be in compliance with the Fit Premises Act. Question number 4. True or false? Under repair and deduct, a tenant can deduct 2 months' rent to make any repair. That is false. A tenant may deduct the actual cost of repairs up to a value of 2 months' rent. Question number 5. True or false? A landlord may cancel the lease if they are unable or unwilling to make repairs. That is true. If the landlord chooses not to make the repairs, the lease is canceled and they must refund the security deposit and any prorated rent. So, how did you do? If you're still struggling with part or all of the Fit Premises module, please feel free to check out the Frequently Asked Questions portion of the website or select the Fit Premises module for a review or contact us at twood@thegoodlandlord.net with any questions. Thank you. During this section, we're going to discuss evictions and the Utah eviction process. First, let's take a short pretest. Question 1, true or false? If my tenant doesn't pay the rent, I can change the locks and keep them out until they pay. That is false. This is considered a constructive eviction and is illegal. The penalties for constructive evictions can be very severe. Question 2, true or false? 3-day notices count court days. That is false. In Utah, 3-day notices are counted on calendar days. Question 3, true or false? If I send a 3-day pay or vacate notice, I can refuse the rent. That is false. If the tenant pays the full amount on the 3-day notice, a landlord must accept the payment. They do not, however, have to accept a partial payment. Question number 4. True or false? Even if I allow pets, I can evict a tenant who now has a pet without receiving my permission. That is true. A tenant must get landlord approval and pay any appropriate deposits or fees prior to getting a pet. Question 5. True or false? A landlord can serve a 3-day notice by leaving it with the neighbors. That is false. This is not an acceptable means of serving a 3-day notice. Crisis resolution is one of the most important parts of being a landlord. Nobody wants to be evicted, and rarely do you have a tenant that should be evicted for any reason. Communicate with your tenants so they understand your needs and try to work out problems and misunderstandings before you both wind up in court. Unlawful detainer means remaining in possession of premises after receiving and failing to comply with a notice to vacate. So the first step in the eviction process is for the landlord to serve the tenant with a notice to vacate. The required type of notice to vacate depends on the tenant's circumstances and is governed by Utah Code Section 78B-6-802. The notice must be in writing and it must strictly follow the statutory requirements. There are 3 causes to terminate a tenancy. The first is failure to pay. The second, failure to comply. And the third is public nuisance. A failure to pay is given when a tenant has become delinquent in their rent payments. This notice is used if the tenant owes rent or other money. This notice tells the tenant they have 3 calendar days to pay the money or move out. It must give the tenant the option to pay the money. If the tenant pays the money, then the tenant can remain on the premises. If the tenant does neither within 3 calendar days after the notice, the tenant is unlawfully detaining the premises. Failure to comply is a failure on the part of the tenant to obey rules and regulations as written in the lease agreement. This notice is used if the tenant has violated a term of the rental agreement that can be corrected. This notice tells the tenant they have 3 calendar days to comply with the agreement or move out. If the tenant complies with the agreement, then the tenant can remain on the premises. If the tenant does neither within 3 calendar days after the notice, the tenant is unlawfully detaining the premises. The third reason to terminate a tenancy is public nuisance. This notice is used if the tenant is creating a nuisance. A nuisance is not just any bad act. A nuisance is something that injures health, is indecent, offensive to the senses, or interferes with someone's free use of their premises. This notice orders a tenant to move out within 3 calendar days. It does not have to give the tenant any other options. If the tenant does not move out within 3 calendar days after the notice, the tenant is unlawfully detaining the premises. There is another kind of notice called a 15-day notice to vacate. This is served prior to the end of a term. It can be changed in the lease agreement to a 30 or 60-day notice if desired. It must be served in accordance with state law, and the landlord does not have to have a reason to end the lease. All legal notices must use Utah-specific notices that refer to the state statute. They must be signed by the owner or the owner's agent, and they must be served in accordance with Utah law. There are 4 ways to serve a 3-day notice. The first is to deliver it to the tenant personally. The second, sending a copy through certified mail. The third is leaving a copy with a person of suitable age and discretion and mailing a second copy. The fourth is posting to the door after failing to find a person of suitable age or discretion. So what is the eviction timeline? First, rent must be past due. You as the landlord get to decide what day that is in the lease. You need to serve a 3-day notice. Not counting the day the notice is served, the tenant gets 3 calendar days to either pay or vacate, or in the case of compliance issues, comply or vacate. After the 3 days has expired, you can file for an eviction with the court or send the file to your attorney to process the eviction for you. The question often comes up, should I hire an attorney to do the eviction? Attorneys are very familiar with the process. They have strict compliance with the rules of the court. They are typically faster and more efficient than doing the evictions on your own. There is a level of emotional detachment. And if you have put your properties into an LLC, you are required to use an attorney. Now we're going to go more in depth into the eviction timeline. If the tenant is unlawfully detaining the premises, that is, has failed to comply with the proper notice properly served, the tenant can be evicted by court order. The complaint to evict must describe the facts that constitute unlawful detainer. Essentially, that the tenant has been properly served with notice to vacate that is appropriate for the circumstances, has failed to comply with the notice, and remains in possession of the premises. The complaint may also allege any fraud, force, or violence on the part of the tenant, and may claim damages and compensation for the occupation of the premises. If the eviction is for failure to pay rent, the complaint must state the amount of rent due. A landlord may not personally issue a summons. The landlord's lawyer or the court must issue the summons. The summons in an eviction is similar to the summons in any civil case. It states the time in which the tenant is required to answer or face judgment by default, and it must contain the other information required by the Utah Rule of Civil Procedure. However, the time to answer is very short, usually only 3 business days from the date of service, unless the tenant objects and the court allows more time. Serving the complaint and summons on the tenant is governed by the Utah Rule of Civil Procedure and Utah Code. The complaint and summons may be served by any person over 18 who is not a party to the case or a party's lawyer. This means that the landlord may not personally serve the summons. The landlord is responsible for filing proof of service with the court. The court can authorize service by an alternative means if the tenant's identity or whereabouts are unknown and cannot reasonably be learned, where service upon all the tenants is impractical, or where the tenant is avoiding service. So who is the plaintiff? A complaint to evict the tenant must name the property owner as plaintiff. Who is the defendant? The tenant and anyone who has signed the lease can be named as defendants. If there is a subtenant occupying the premises, the subtenant also can be named as a defendant. The landlord may, but does not have to, sue all of them, but the landlord can obtain a judgment only against those who are served with process or appear in the proceedings. Once the complaint and summons are served on the tenant may file a written answer with the court within the time stated in the summons. The tenant must serve a copy of the answer on the landlord by one of the methods described in Utah Rule of Civil Procedure. What if the tenant fails to answer? If the tenant does not file an answer to the complaint and summons within the time frame ordered by the court, the landlord may file for a default judgment and ask the court to issue an order of restitution of the premises. In an occupancy hearing, the judge will hold a hearing within 10 days after the day on which the tenant files an answer, if the complaint to evict claims failure to pay rent, or the new owner of the premises is evicting the former owner after a forced sale. At the hearing, the judge will determine who has the right to occupy the premises while the case moves forward. In the case of criminal nuisance, if the complaint alleges an offense designated by Section 78B-6-810 as a criminal nuisance, the court will hold an evidentiary hearing within 10 days after the day on which the complaint is filed to determine whether the alleged act occurred. The hearing will be set when the complaint is filed, and notice of the hearing must be served upon the tenant with the summons at least 3 calendar days before the scheduled time of the hearing. If the tenant fails to appear at the hearing after having received notice of it, the judge will issue an order for restitution of the premises, directing the sheriff or constable to return possession of the premises to the landlord. If the judge finds that all the issues can be decided without further proceedings, the judge will decide those issues and enter judgment on the merits. If the judge decides there is a need for further proceedings and the tenant remains in possession of the premises, the judge will begin the trial within 60 days after the day on which the complaint was served, unless the parties agree otherwise. If an answer is filed, then all parties must follow rules of civil procedure governing discovery and disclosure. Because evictions occur quickly, there may be court hearings scheduled before either party needs to make initial disclosures. If the judge enters a judgment for the landlord, whether after trial or after the occupancy hearing, whether by deciding the merits of the claims or after the tenant's default, the judgment will include an order for restitution of the premises, directing the sheriff or constable to return possession of the premises to the landlord. If the complaint to evict claims failure to pay rent or failure to perform a requirement of the rental agreement, the judgment will also end the rental agreement, but the tenant still owes the rent for the remainder of the agreement, limited by the landlord's duty to reduce damages, usually by renting the premises to someone else. The judgment may also award to the landlord the rent for the time the tenant lawfully possessed the premises and 3 times the actual damages from rent and other money due under the contract for the time the tenant unlawfully detained the premises, forcible entry, forcible or unlawful detainer, waste of the premises, and the abatement of the nuisance by eviction. The restitution order directs the tenant to vacate the premises, remove the tenant's personal property, restore possession of the premises to the landlord, or be forcibly removed by a sheriff or constable. The judgment may also include the landlord's reasonable attorney's fees, and this amount is not trebled. The landlord must prove all of these damages, and the rent and the attorney's fees, and this is often done by the landlord filing an affidavit describing these items. Even if the tenant defaults, or does not answer the complaint, the landlord must serve the tenant with the affidavit of damages and notice of any hearing to determine damages. The restitution order also advises the tenant of deadline to vacate the premises, which is usually 3 calendar days following the service of the order. Also advises the tenant of the tenant's rights to a hearing to contest the manner in which the order is enforced. The restitution order and a form for the tenant to request a hearing must be served on the tenant by a peace officer, a sheriff or constable, or a private investigator. The restitution order and form must be served by one of the methods for serving a notice to vacate. The person serving the order and form must file proof of service under Utah Rule of Civil Procedure. The tenant may request a hearing to contest the manner in which the order for restitution of the premises is enforced. The tenant must nevertheless obey the order and vacate the premises. The court will set the hearing within 10 days from the filing of the request for hearing, or as soon as possible after that. If the tenant fails to comply with the order for restitution of the premises, a sheriff or constable may enter the premises by force, using the least destructive means possible to remove the tenant. The sheriff or constable may remove the tenant's personal property and store it. The tenant may not recover the property until the moving and storage costs have been paid. The tenant must be provided reasonable access within 5 business days to retrieve clothing, identification, financial documents, medical information, prescriptions, and medical equipment. If the tenant does not pay moving and storage costs to recover the property within 15 calendar days, the property is considered abandoned and may be sold or donated. Now a short test on evictions. Question 1. True or false? I have to wait to get an order of restitution of premises before changing the locks. That is true. Locking out a tenant without the order is considered a constructive eviction. Question 2. Which of the following is not a reason for eviction? 1. Unpaid rent. 2. A lease violation. 3. A tenant divorce. Or 4. Criminal activity. The answer is number 3. A tenant divorce. If tenants divorce and one moves out, they're both still legally liable for the term of the lease. Question 3. True or false? I have to wait 5 days after serving a notice to start an eviction. That is false. Not counting the day a notice is served, a landlord must wait 3 calendar days to start an eviction. Question 4. True or false? I have to use an attorney to do an eviction if I have my rentals in a limited liability corporation. That is true. An attorney is required to represent an LLC in eviction matters. Question 5. What notice should be served on a tenant who brings in a pet in violation of their lease agreement? A 3-day comply or vacate. So, how did you do? Being able to know the eviction process is important for landlords. If you struggled with any part of the eviction presentation, please feel free to review the eviction module or contact us at The Good Landlord with specific questions. In this section, we'll be talking about abandonment, discussing the laws that pertain to abandoned property and abandoned premises. Prior to discussing abandonment, we'd like to take a short pretest to see what you already know. Question 1. How long must a landlord hold abandoned belongings? The answer is 15 days. Question 2. A landlord can require a tenant to pay all the outstanding rent before returning abandoned property. That is false. And question 3. A landlord must hold abandoned pets. That is false. So how did you do? Many of you already knew the answers to these questions. For you, much of the information in this module will be a review. If you didn't know or weren't sure of the answers, this module will help you better know how to handle situations of abandonment. As we discuss abandonment, we hope that you'll be able to learn several different things. First, the different types of abandonment. Second, when to declare an apartment abandoned. And third, what to do with things that are left behind by tenants. There are 2 types of abandonment that occur in rental properties. The first is known as premises abandonment. The second, property abandonment. In discussing premises abandonment, landlords sometimes find that with skips or even scheduled move-outs, a tenant may leave a few belongings behind. This raises several questions. The first is, can I still declare the apartment abandoned? The second, do I have to store the belongings that have been left behind? And third, should I continue to charge rent? We'll discuss these and more issues in the upcoming slides. There are 2 kinds of premises abandonment. The first is called one-day abandonment. In one-day abandonment, the rent is past due and the tenant has moved all their belongings from the rental. This is called a skip, where the tenant skips out of the rental without paying or giving notice that they intend to move. What if there are still some belongings? If the belongings that are left behind are trash, then they may be discarded and the unit declared abandoned. Things of value, however, must be stored. In this instance, this is trash. Throw it away. For something like this, while they may not be your favorite chairs, they're not trash and must be kept. The second type of premises abandonment is known as 15-day abandonment. With 15-day abandonment, again, rent is past due, but items still remain in the rental, and there's no reasonable evidence that the tenant is still living there. So what constitutes reasonable evidence? First, try to contact the tenant. Call their home and cell phone numbers. Call their emergency contact number. Try to reach them at work. Talk with the neighbors. And visit the rental several times. If there's still no evidence that the tenant is living there, then the unit can be declared abandoned. After 15 days, the unit can be declared abandoned, and a 24-hour abandonment notice must be posted on the front door, facing out, taping all four corners. Then, after waiting 24 hours, you can change the locks and take possession of the unit. That brings us to the second kind of abandonment, abandoned property. Abandoned property can occur following an eviction, a 1-day or 15-day abandonment, or even a scheduled move-out. When dealing with a former tenant's abandoned belongings, it's recommended to make a detailed inventory in writing and take pictures or videos of everything left behind. Sometimes making the inventory can be difficult, but be detailed. Utah law was modified in 2013 to require landlords to store property for at least 15 days rather than 30 days, as it had been previously. A tenant may reclaim some belongings within 5 days without any cost. These items include medical equipment and prescriptions, documents, and clothing. Some items do not need to be stored. These include hazardous chemicals or materials such as gasoline, vehicles, pets, perishable items like food, and garbage. A tenant may request that a landlord store the belongings for an additional 15 days for victims of domestic violence, for tenants who have been hospitalized, and for estates of deceased tenants. State law is not specific about where you need to store the belongings, other than they must be in a secure location. Many landlords don't want the hassle or expense of moving the belongings, so they simply leave them in the apartment for 15 days and then dispose of them. Remember though, when you do this, you're losing rent every day you store those items. So what should be done? So, what are my options when it comes to storing a former tenant's abandoned property? You can store it right where it's at, in the abandoned apartment. You could move it to another rental that you own. You could store it in a garage or storage shed on the property, or you could store it in an offsite storage. What's the best choice? The best choice is usually an offsite storage unit. Moving the belongings to a storage unit is a great way to secure the belongings, and it allows for a new tenant to move into the apartment. The tenant has the right to reclaim their belongings within 15 days of being served the notice of abandonment. The items may be reclaimed by the tenant if they pay the landlord's reasonable moving and storage costs. If the tenant has not reclaimed the abandoned property within 15 days, the landlord may dispose of the property in the following manner. They may throw it away, They may donate it to charity, or they may sell it at auction. If the belongings are sold, any proceeds must be applied to the tenant's balance due. It's important to properly follow the rules of abandonment. If abandoned property is not held for at least 15 days, the landlords can be charged treble damages by the courts. The following are frequently asked questions regarding abandonment. Can I make the tenant pay their back rent before giving them back their belongings? The answer is no. If the tenant asks for their belongings during the 15 days a landlord is required to hold them, and they pay reasonable moving and storage costs, you must return their belongings. What should I do if the tenant leaves a pet behind? Contact Animal Control or the Humane Society. A landlord is not required to keep and maintain an abandoned animal. Can I keep the abandoned belongings left behind by the tenant? It is recommended that any items of value that are left behind be sold at auction in order to satisfy the debt owed by the tenant. And now a short abandonment quiz. Question 1. True or false? If the tenant hasn't been seen around the rental for more than 15 days, it can be declared abandoned. That is false. Rent must also be past due for a unit to be declared abandoned. Question 2. A landlord must hold a tenant's belongings for how many days before they are allowed to dispose of them? The answer is 15 days. Question 3. A tenant must pay what in order to get their abandoned property back from the landlord? The answer is reasonable moving and storage costs. Question 4. True or false? A landlord must hold a tenant's cat for 15 days if it's been left behind. That is false. A landlord does not need to store pets. Question 5. True or false? A tenant may require that a landlord store their belongings for 15 additional days if they are out of the country. That is false. Being out of the country does not allow you to receive extra time. So how did you do? Being able to know what to do with abandoned property is important for landlords. If you struggled with any part of abandonment, please feel free to review the abandonment module or contact us at The Good Landlord with specific questions. Now we'd like to discuss fair housing and the important part it plays in the rental housing industry. Before we begin, let's take a quick pretest to see what we already know. Question 1. True or false? Fair housing laws only apply to big apartment communities. That is false. Fair housing laws apply to everyone in the rental housing industry. Question number 2. True or false? I can ignore fair housing laws if I feel that I'm helping the person find housing that fits them better. That is false. Individuals have the right to choose for themselves. Question 3. Which of the following is not protected by federal fair housing laws? Color, race, sexual orientation, or religion? The answer is 3, sexual orientation, which is protected in many cities throughout Utah. Question number 4. True or false? If I refuse to translate my lease into Spanish, I am discriminating against a person because of their national origin. That's false. A landlord is not required to have their lease in any language except for English. Question number 5. True or false? The number one cause for fair housing complaints in Utah is religious discrimination. That's false. The number one cause for complaint in Utah and throughout the nation is on the basis of a person's disability. The purpose of federal fair housing laws is to prevent discrimination in housing by making it illegal for anyone to refuse to rent to someone because of their race, color, religion, sex, national origin, handicap or disability, or familial status. So what is illegal? It is illegal to threaten, coerce, intimidate, or interfere with anyone exercising a fair housing right, or who is assisting others who exercise that right. It is illegal to advertise or make any statement that indicates a limitation or preference based on membership in a protected class. It also prohibits discrimination in housing due to membership in a protected class. So what is prohibited? It's prohibited to refuse to negotiate for housing. This applies when someone offers you less than an advertised amount of rent. If you negotiate with one person, you must negotiate with all persons. It doesn't mean you have to accept a lower rent, only that if you're willing to do so, that you do it with all people. It is also prohibited to refuse to rent. This is simply choosing not to rent to persons based on their membership in a protected class. For example, I won't rent to Hispanic applicants. It is prohibited to make housing unavailable. Telling a person that an apartment is no longer available because of their protected class. For example, telling a family with children that an apartment has already been rented, then renting it to someone without children. The following video gives an example of making housing unavailable. Setting different terms, fees, conditions, or privileges is also prohibited. Setting different rules because someone is in a protected class. For example, a landlord charging a higher security deposit to a family with children, assuming they will cause more damage to the apartment. Steering is also prohibited. Steering often happens when landlords think they are being helpful. For example, a landlord might offer a ground floor apartment rather than a second floor unit to a single mother with 2 small children, thinking it's easier for her not to have to go up and down stairs. She's been treated differently because of her familial status. Now let's discuss the different protected classes. There are 7 federally protected classes: race, color, religion, sex, national origin, handicap or disability, and familial status. The Fair Housing Act of 1968 protects a person's housing rights based on race. Race or ethnicity includes the following: Black or African American, Hispanic or Latino, white, Native American or American Indian, Asian or Pacific Islander. These are examples of different types of race. The Fair Housing Act of 1968 also protects a person's housing rights based on color. Color is similar to race, but the term color usually refers only to skin color or pigmentation, while the term race usually refers to both physical characteristics and ethnological classifications. Physical characteristics sometimes associated with race include facial features, hair texture, and skin color. The Fair Housing Act also protects a person's housing rights based on their religion. Religion is a particular system of faith and worship which includes the following: Christians, Jews, Muslims, and atheists. The Act also protects a person's housing rights based on sex. This is simply male or female. It also protects a person's housing rights based on their national origin, treating someone differently because of the country where they were born. For example, choosing not to rent to someone because they are from Mexico and speak Spanish. The Fair Housing Act of 1968 was amended in 1988 to protect persons' housing rights based on familial status. Familial status does not attempt to define a family. Rather, it affords protection to any household that contains children under the age of 18. Remember that familial status protection is granted to households containing one or more people under the age of 18 who live with a parent or a guardian. Pregnant women, foster families, people in the process of adopting a child under the age of 18, and households in the process of acquiring custody of a child under the age of 18. The amended Act of 1988 also protected persons' housing rights based on their handicap or disability. The definition of disability is broad, so just because an individual doesn't appear to have a disability doesn't mean that they aren't disabled. Disability is defined as any person who has any physical or mental impairment that substantially limits one or more major life activities. A person with a record of such physical impairment or mental impairment. A person regarded as having such an impairment. There is also one Utah protected class. It is source of income. It is illegal to discriminate against someone because of where they get their income. It can be from sources such as alimony, child support, or a housing authority voucher. Landlords can't say, "I don't accept housing." There are also two city protected classes. Gender identity and sexual orientation are protected in the following Utah cities and counties: Salt Lake City and Salt Lake County, Park City and Summit County, Taylorsville, West Valley City, Marriott-Slaterville and Murray, Midvale, Moab, Grand County, Ogden, Logan, Alta, Harrisville, Springdale, South Salt Lake, Perry City, and Washington Terrace. There are severe penalties for violating fair housing law. For violating federal fair housing law, there's a $10,000 administrative fine for each instance of discrimination. If you have employees and they commit a fair housing violation, you may also be fined. In addition to the administrative fine, there are civil penalties. Compensatory civil penalties are $16,000 for a single offense, $65,000 for a second offense. In determining the amount of the civil penalty to be assessed against any respondent for each separate and distinct discriminatory housing practice the respondent committed, the administrative law judge shall consider the following factors. First, whether that respondent has previously been adjudged to have committed unlawful housing discrimination. Second, that respondent's financial resources. Third, the nature and circumstances of the violation. Fourth, the degree of that respondent's culpability. And fifth, the goal of deterrence. There are also severe punitive penalties. Punitive damages are assessed to punish those who commit fair housing violations. In 2009, former LA Clippers owner Donald Sterling was fined $2.75 million over a housing discrimination suit. There are two types of discrimination. The first type is called disparate treatment. This is simply treating someone of a protected class differently. For example, choosing not to rent to a person simply because they are Hispanic. The second type of discrimination is called disparate impact. This is using a neutral policy or procedure that has a disproportionately negative impact on a protected class. For example, not renting to a person because they smell like curry and you're worried the apartment will smell from their cooking. In January of 2014 in Dallas, Texas, the U.S. Justice Department settled a housing discrimination lawsuit over discrimination against Middle Eastern and South Asian persons. Under the order, the defendants will pay a total of $107,000 in civil penalties and $210,000 in damages to compensate victims. According to the suit, the apartment manager told her leasing agents they were prohibited from leasing to Middle Eastern or South Asian people unless there were openings in buildings 16 or 18, which were designated for curry people. Now some questions. Is this a fair housing violation? Here are several scenarios. Can you determine the proper procedure? Landlords are required to reasonably accommodate an applicant or resident who has a disability. Do similar requirements apply for requests for religious accommodations? The answer is no. Here are a few examples. Juan is a Jehovah's Witness and is offended by Christmas decorations in his apartment community. He visits the office and requests that the decorations in the public and common areas be removed. Do we have to remove them? No, this is not a violation of his fair housing rights. Abdul is a Muslim and does not want anyone walking into his apartment with shoes. When the maintenance employees enter to perform their duties, he requests that they remove their shoes and walk around his apartment in their socks. Do you have to do this? No, this is not a requirement under federal fair housing law. Shane is a member of a fundamentalist Jewish sect that believes that prior to marriage, men and women should not touch in any way and not even be alone in a room. When he comes in to apply, a female leasing employee offers to shake his hand, which he angrily rebuffs, and then refuses to go into your office to discuss his application. Have you committed a fair housing violation? No. Again, we do not have to make accommodations for an individual because of their religion. There is no requirement that a landlord must accommodate a person's religion. Therefore, if a religious practice interferes with the normal business operations of your apartment community, you do not have to change your practices. In the instance of maintenance practices, there are many safety considerations that would take precedence over a religious accommodation request. The bottom line is, you are required to not discriminate against persons because of their religion, but you are not legally required to accommodate someone's religious beliefs. Landlords are not required to provide their services and documents in languages other than English. If you choose to translate a document into a second language, such as Spanish, and also have it available in English, you do not then have to provide it in other languages, such as Chinese or Russian. Develop policies concerning language based on the need of your residents and your market, and don't avoid providing expanded language services to a large group you are currently servicing because of a concern that you'll have to provide such services for all languages. Disability is the #1 reason for fair housing complaints in Utah and in the United States. Almost 50% of fair housing complaints are because of discrimination against persons with disabilities. Persons with a disability can make requests of their landlords to accommodate them because of their disabilities. These requests fall into 2 categories: a reasonable modification and a reasonable accommodation. A reasonable modification is a change to the physical characteristics of a residence or to the common areas of a building, including installing a ramp, widening doorways, or installing a lift. The request must be reasonable, and the tenant must pay to make and remove the modification. The second type of request is a reasonable accommodation. This is a change in rules, services, practices, or policy that do not change the nature of the program, such as providing a rent reminder, providing reserved accessible parking, or allowing a service animal. We're going to spend some time discussing service animals, as this is an area that a lot of landlords don't understand. The ADA defines a service animal as any guide dog, signal dog, or other animal individually trained to provide assistance to an individual with a disability. If they meet this definition, animals are considered service animals under the ADA, regardless of whether they have been licensed or certified by a local or state government. Service animals do not have to be licensed or have specific training. This is the same for reasonable requests to accommodate a companion, comfort, or therapy animal, regardless of the type of animal. There have been requests for unusual service animals. A Seattle resident says his almost 5-foot boa constrictor is a service snake. The reptile, who rides around town on his neck, helps alert the Washington man to impending seizures by squeezing him more tightly when he's about to have one, giving him time to take his medication. Miniature horses serve as seeing eye animals. They can live for more than 30 years. In that time, a person needing a service animal typically goes through 5 to 7 guide dogs. That can be draining both emotionally and economically, because each one can cost up to $60,000 to breed, train, and place in a home. The question often comes up, are they service animals or are they pets? Service animals are not considered pets. Because of this, you cannot charge pet rent or an additional deposit or set restrictive rules for the pet. Do I have to believe every person that says they're disabled and wants a service animal? The answer is no. A person requesting a reasonable accommodation should provide verification that they have a disability and that there is an identifiable relationship between the disability and the requested accommodation. If the disability is obvious and the need for the requested accommodation or modification is apparent, then the landlord may not ask for further verification. If the disability is obvious, but the need for the accommodation or modification is not, the landlord may only ask for necessary disability-related information. If the disability is obvious and the need for the requested accommodation or modification is apparent, then the landlord may not ask for further verification. If the disability is obvious, but the need for the accommodation or modification is not, the landlord may only ask for necessary disability-related information. If the disability is obvious and the need for the requested accommodation or modification is apparent, then the landlord may not ask for further verification. If the disability is obvious, but the need for the accommodation or modification is not, the landlord may only ask for necessary disability-related information. If the disability is obvious and the need for the requested accommodation or modification is apparent, then the landlord may not ask for further verification. If the disability is obvious, but the need for the accommodation or modification is not, the landlord may only ask for necessary disability-related information. If the disability is obvious and the need for the requested accommodation or modification is apparent, then the landlord may not ask for further verification. If the disability is obvious, but the need for the accommodation or modification is not, the landlord may only ask for necessary disability-related information. If the disability is obvious and the need for the requested accommodation or modification is apparent, then the landlord may not ask for further verification. If the disability is obvious, but the need for the accommodation or modification is not, the landlord may only ask for necessary disability-related information. There are exemptions for some from federal fair housing laws. If an owner has no more than 4 units and lives in one of the units, they are exempt from federal fair housing laws. Or if a private individual does not own more than 3 houses, they are exempt. You are not exempt from fair housing if you're a real estate agent or in the business of real estate, even if you qualify for an exemption. And no one is exempt when it comes to advertising rentals. Question number 1. True or false? If I have a vacant second floor apartment, I don't have to rent it to a person in a wheelchair. That is false. I should treat them like every other person and let them decide if they want to rent it. Question number 2. I only have one house that I rent out, so I don't have to follow fair housing laws. That is true. A private individual with 3 or fewer rentals is exempt from fair housing. Question number 3. Under federal fair housing laws, it is illegal to prohibit which of the following in a housing unit? 1. Smoking. 2. Pets. 3. Families. Or 4. Firearms. The answer, of course, is families. Question number 4. True or false? I don't have to put in a ramp for my tenant if I can't afford to pay for it. That's false. A tenant must make a reasonable request and then pay for the modification requested. The landlord does not pay for a reasonable modification. Question number 5. True or false? After a tenant moves in, I don't have to worry about fair housing anymore. That is false. You must continue to follow fair housing laws at all times and in all circumstances. Question number 6. Which of the following is protected by city rather than federal fair housing laws? Color, race, sexual orientation, or religion? The answer is sexual orientation. Question 7. True or false? Fair housing laws only apply to big apartment communities. The answer is false. Fair housing applies to everyone. You have now completed the Good Landlord refresher training. Following is a short test which will review each section that was discussed. Following the test, you will be given directions for how to obtain your Good Landlord certificate to receive your business license discount from the city. The final test is made up of 20 questions, 5 from each section that was discussed today. Fair housing, question 1. True or false? A reasonable accommodation request can be denied if there is not a relationship between the disability and the requested accommodation. That is true. A disabled person may make a reasonable accommodation request, but there must be a relationship between their disability and the request. Fair housing, question 2. Who is exempt from fair housing? A person who rents their basement. B, a real estate agent with 2 rentals. C, anyone who doesn't have a real estate license. Or D, none of the above. The answer is A, a person who rents their basement. If a private individual has less than 3 units, they are exempt from fair housing laws. Fair housing, question 3. True or false? A landlord can require a person in a wheelchair to rent a handicap-accessible apartment. That is false. A landlord needs to provide the same options to someone in a wheelchair as any other person looking for an apartment. Fair housing. Question 4. Under federal fair housing law, the 7 protected classes include A. Race, color, source of income, religion, disability, national origin, and marital status. B. Race, color, religion, sex, disability, familial status, and national origin. C. Race, sexual orientation, familial status, disability, national origin, age, and sex. Or D. None of the above. The answer is B. In Utah, source of income is an additionally protected class, and in several cities throughout Utah, sexual orientation and gender identity are also protected. However, the federally protected classes are race, color, religion, sex, disability, familial status, and national origin. Fair housing, question 5. True or false? Under federal fair housing law, a landlord is required to pay for reasonable modifications for disabled tenants. That is false. A landlord is required to make reasonable modifications, but the tenant making the request is required to pay for those modifications. Abandonment, question 1. True or false? A landlord must store all abandoned belongings for 15 days. That is false. A landlord is not required to store dangerous chemicals, pets, trash, or perishable items. Abandonment, question 2. True or false? If the tenant hasn't been seen for 3 weeks, the landlord can declare the unit abandoned. That is false. Tenant must also be delinquent on their rent, and there's no reasonable evidence that the tenant is no longer occupying the apartment. Abandonment, question 3. Which of the following items from an abandoned apartment do landlords need to store for 15 days? A. Medical equipment. B. Furniture. C. Clothing. Or D. All of the above. The answer is D. All of the above. A tenant may request within 5 days, at no cost, to have clothing and medical equipment as well as documents returned to them. But a landlord still has an obligation, even after those 5 days, to continue to store those items. Abandonment, question 4. True or false? A landlord can require a former tenant to pay their outstanding balance to reclaim their abandoned belongings. That is false. In order to reclaim their abandoned belongings, a tenant must pay reasonable moving and storage costs within the first 15 days. Abandonment, question 5. True or false? If a tenant has not paid rent and has removed their belongings, a landlord does not need to wait 15 days to declare an apartment abandoned. That is true. This is a one-day abandonment, and it is perfectly legal for the landlord to retake possession of the apartment that first day. Evictions, question 1. True or false? After serving a 3-day pay or vacate notice, a landlord must accept any payment made by the tenant as long as it's within the 3-day period. That is false. A landlord must accept full payment made within that 3-day period. If a tenant attempts to pay a partial payment, the landlord has the option to reject the payment or to accept the payment and reissue a new 3-day notice with the proper balance due. Evictions. Question 2. Which of the following is not a legal means of serving a 3-day notice? A. Posting it on the front door. B. Delivering it to a neighbor. C. Sending it by certified mail. Or D. Delivering it to the tenant at their place of work. The answer is B. Delivering it to a neighbor is not a legal way to serve a 3-day notice in the state of Utah. Evictions. Question 3. True or false? A landlord may file for an eviction if a tenant moves in a roommate without getting approval from the landlord. That is true. Any person that wants to move into the apartment should go through the application and approval process. Evictions. Question 4. In Utah, how are days counted when serving 3-day notices? A. Calendar days. B. Business days. C. Court days. Or D. None of the above. The answer is A. Calendar days. We are able to count the days regardless of whether they're on a weekend or a holiday. Evictions. Question 5. If a landlord chooses to not extend a lease after it expires, they are required to serve which type of notice? A. A 3-day pay or vacate. B. A 3-day comply or vacate. C. A 3-day nuisance. Or D. None of the above. The answer is D. None of the above. If a landlord is going to terminate a lease at the expiration of the lease, they're required to send a 15-day notice to vacate, unless there's a provision that's different in the lease. Many landlords have a requirement of a 30-day notice, and some a 60-day notice. Fit premises. Question 1. Which of the following is a landlord not required to provide under the Fit Premises Act's habitability provision? A. Hot water. B. Air conditioning. C. Running water. Or D. Heat. The answer is B. Air conditioning. If air conditioning is provided to the tenant at the time they move in, then under the Fit Premises Act's habitability provision, a landlord must maintain that air conditioning. There is, however, no requirement that a landlord install or provide air conditioning for any tenant. Fit premises. Question 2. True or false? A tenant can withhold their rent to force a landlord to comply with the Fit Premises Act. That is false. One of the provisions of the Fit Premises Act is that a tenant must be current on their rent in order to exercise their rights under the Fit Premises Act. Fit premises. Question 3. How long is the corrective period to repair a refrigerator that is no longer working? A. 3 days. B. 10 days. C. 24 hours. Or D. 15 days. The answer is 10 days. An inoperable refrigerator falls under the category of deficient condition under the Fit Premises Act, and a landlord has 10 days to take substantive corrective action. Fit premises. Question 4. True or false? If a landlord does not make repairs to an apartment, a tenant may make the repairs themselves and deduct the cost of the repairs from their rent. That is true. Under the Fit Premises Act, if a tenant is current on their rent, and they've given proper notification to the landlord, and the landlord still chooses not to make repairs, one of the options available to the tenant is to repair and deduct. They can make the repairs themselves and deduct the actual cost of the repairs up to 2 months' rent in value from any future rent owed to the landlord. Fit premises. Question 5. True or false? State law requires that all landlords give a 24-hour notice prior to entering into any rental unit. That is false. Under the Fit Premises Act, the default is 24-hour notice. However, the law allows landlords to change the notice requirement in their lease agreement. Congratulations! You made it through the Good Landlord Refresher Training, as well as the test. How did you do on the test? Following the training, most landlords can answer 15 or more of these questions correctly. If you were correct on 15 or more, you've done well. If you scored less than 15, you might want to review specific sections where you struggled. Now it's time to get you your certificate. Now that you've completed the training, email this code, AHMS1-27, to twood@thegoodlandlord.net. You will receive your certificate within 24 hours. Thank you, and please contact us with any questions, concerns, or feedback.